So the notario will ask, okay, what is it that you want to put into the will? If it is a property, and that's all the person has, and most of us have cars, all of us have heirlooms, family, old coffee maker, or something that is worth something, but it's basically items, not fixed assets such as a home. I always suggest that, stick with the fideicomiso. If you do have a fideicomiso as a foreign individual, it's just a matter of reviewing the way that the property would be passed on to your beneficiaries, say husband and wife. Husband and wife must name each other as their own respective beneficiaries in the event of the other's death, so that the surviving spouse receives the portion that the deceased left, right? And there's always an alternate beneficiaries, which are normally the children or family or a charity, okay? But you have to understand that in itself in a fideicomiso is estate planning, right? And I always suggest that if you have a fideicomiso, not to worry about a will, because the most relevant asset that you have is actually your home, right? Unless you have complications such as being hugely wealthy. But if you are, and if you're a foreign national, you usually don't have all your ducks in Mexico. You have an elsewhere, and you have your living trust and your living will in the U.S. Keep it there. Don't toy with it. But whatever you have in Mexico, and the most relevant part of your state happens to be the home, and you do have the fideicomiso, you already have state planning. So what about the will? Should I have a will or not? Well, I would not include the home in the will because you already listed in the fideicomiso, right? But whatever you want to leave, such as a car or art or tables, chairs, pictures, that you include in the will.
Can you include bank accounts in your will?
You can, yes. What is the most common description or instruction, should we say? I have one daughter, and I'm leaving Michelle as my universal heir, and she will receive my estate, nothing else. When there's more than one beneficiary, such as a widow or ex-wives or children with the same spouse or not, that I guess it becomes complicated. That's where you need the support of the notario in order to do the right thing and be able to have clear instructions without allowing this or trying to avoid this going to litigation, because there's a misinterpretation, there's fighting between siblings, or there's more than one a marriage in the past of the individual. So yeah, in those cases, you definitely have to have a will. But as I said, it depends on this complications or the state, how wealthy or how complicated the state is. And again, all the financials that people have back home, Canada, the States, what a living will, what a living trust in the U.S., that has already been taken care of. Unless you're a permanent resident of Mexico and you have everything in Mexico, okay, yeah. So keep the fideicomiso, don't put the property in the will. And you would ask, why not? Isn't the will protection? No, it is protection, but you already have estate planning in the fideicomiso. What happens if I have a will and put a property there, or if I have a fideicomiso, someone has a fideicomiso and name someone the beneficiary. When I die as a Mexican and left the will, the person who's the beneficiary will have to file for probate, go to court, get an attorney, spend $12,000 or more. Some attorneys even charge a percentage of the worth of the state in order to take care of the case. That is criminal, but that's the practice. Guess why many attorneys get rich? Because they do that, and people that love it. So anyways, when you have a will, regardless of the fact that there's a will and there's someone named as the beneficiary, it has to go to court. It has to go to probate. But if you have this other person which left the home in a trust and there's someone named there as a beneficiary, that person does not need to file for probate, doesn't need an attorney. They only need to notify the bank that the beneficiary of the trust passed away, and based on the instructions, I'm asking you to update the Fideicomiso and have me as a sole or surviving owner of the property. So yeah, there's a wide difference. That's why I insist that the Fideicomiso could provide us all the protection you need, but if there's complexities such as I said, bank accounts, investments, insurance, even pets. I help people that have pets that actually name and left $30,000 for a pet. Yes, because that's the way they want it, to be protected. So yes, depending on the person's needs and the obligations or the number of beneficiaries, it might just end up having to have a will. But if you have a Fideicomiso, don't include the household in the Fideicomiso in the will. It will have you burdened by having to file probate, because now you complicated to the point that you need to have the attorney. So Fideicomiso, have property there. If you have a will, put all the belongings, the cars, whatever, into that will. The notarios, during the month of September, charge 50% all over Baja, pretty much the whole 32 states, actually. I've seen it elsewhere as well. But in Baja California, during this month of September, is the month of the will, el mes del testamento, has 50%. So it usually is around 2,400 pesos, all inclusive. When you give the will, the notario records with the state, and it's, well, we call it Dirección General de Notarías. But everything, all inclusive, 2,400 pesos, it takes about a week. And it takes sometimes, depending on the notario, as much as 7 hours.
Thank you for watching our video. If you're planning on buying real estate in the Rosarito Beach area, make sure to give us a call. Have a great day, everybody.